A recent order by a U.S. district judge called into question Judge Analyst Torres' finding in the Ripple lawsuit, which declared certain XRP purchases to be non-security offerings. Ripple has unlocked 400 million XRP from escrow, and the community has been astonished, with an unusual memo. Finally, will Ripple win because of the presence of an extra judge? Continue reading to the end to find out more. If this sounds like something you'd be interested in, make sure to watch this new video right now. Hello and welcome to our channel, where we discuss the newest XRP news and the cryptocurrency world in general. If you're watching one of our videos for the first time, we'd like to extend a warm welcome. We encourage you to activate the notification bell so that you never miss any video. We are pleased to announce that this channel is hosting a 200 XRP giveaway. To be eligible, simply subscribe to the channel, like this video, and leave a comment with the hashtag XRP, and the winner will be announced. On August 15th, a recent development involves SDNY District Judge. In a recent development, SDNY District Judge Jed Rakoff dealt a serious blow to the XRP ruling. The ruling of the judge permits the SEC to continue its case against Terraform Labs and its founder. Do Kwon categorically denies the distinction between public and institutional sales stated in the Ripple litigation. The court's ruling on Terraform Labs. The case comes to light courtesy of John Reed Stark, who brought it to the attention of the public. Thanks to Twitter, Judge Rakoff's decision on Terraform Labs' move to dismiss this SEC's case against them was revealed by Stark, a former SEC attorney in the agency's enforcement division. Remember that Terraform Labs and Do Kwon's lawyers had requested that the SEC's complaint be dismissed. The lawyers referenced the Ripple decision to argue that the assets in dispute are not securities under the SEC's jurisdiction. The SEC, on the other hand, responded by arguing against following Judge Analyst Torres' reasoning in the Ripple case and expressing its intention to appeal the verdict. Judge Rakoff denied Terraform Labs' move to dismiss the SEC action, claiming that the SEC has jurisdiction, and a reasonable claim that Terra USD, the Anchor Protocol, and Luna breached securities laws. Judge Rakoff directly disputed Judge Torres' judgment in the Ripple case in an assertive statement, stating his disagreement with the approach employed in that judgment. He criticized the Ripple case's distinction between public and institutional sales. According to him, the Howey test does not distinguish between consumers depending on the provenance of their coins, because all purchasers can fairly expect to profit from the defendant's efforts. The judge's decision also called into question the Major Questions Doctrine, a Supreme Court decision that prohibits regulatory agencies from exceeding their jurisdiction. The argument has been utilized by some cryptocurrency defendants, including Coinbase, against the SEC. Judge Rakoff rejected this issue, finding that the Bitcoin business lacks the vast economic and political significance of other regulated industries. To underscore the gravity of this ruling, Stark pointed out that Judge Jed Rakoff is widely recognized as one of the most distinguished securities law jurists in the United States federal court system. Rakoff's reputation as an independent thinker was again emphasized by the former SEC attorney. Ripple's CTO, David Schwartz, voiced reservations about the court's decision, stating that it appeared to rely on the particular attributes of Terraform Labs' scheme rather than the generic characteristics of cryptocurrencies. According to Schwartz, the court's rejection of the Ripple case did not appear to be founded merely on a fundamental disagreement with its rationale. Instead, it is based on the factual distinctions between the two cases. He proposed two possible readings of the court's decision. In one case, the court disagreed with the Ripple ruling because it applied additional factors not included in the Howey test. As a result, it suggests that the court may not apply or follow the Ripple decision in this case. This, according to Schwartz, is the worst. The argument in favor of Torres' decision. The second reading is that the court rejected the idea that it should adopt the Ripple decision in the Terraform case because of idiosyncrasies in the Terraform Labs action, rather than because of the Ripple ruling. The Howey factors are intimately implicated. In this judgment, the court considers that despite the specific facts in the Ripple case explaining the distinction between public and institutional transactions, these factors may not be applicable in the Terraform Labs case. According to Schwartz, this would be the best case for proponents of Tor's decision. In light of recent developments, the price of XRP has fallen below $0.70. Yesterday, XRP fell below the psychological support level of $0.70 for the first time since July 13. The asset is now at $0.69, down 2% in the last 24 hours. Please remember to subscribe to our channel and press the notification bell to be among the first to learn about the latest XRP developments. Ripple's escrow of XRP tokens has been released. As part of its monthly escrow execution exercise, Ripple has unlocked XRP tokens from its escrow wallets as part of its monthly escrow execution. However, one of the escrow execution transactions involving 400 million XRP contained an unusual message, piquing the interest of community members as to its origin and the organization responsible. In a recent tweet, well-known XRP community personality Mr. Intuitive attracted attention to the puzzling document. The community influencer expressed his amazement and awe at the message's content. The document was linked to an escrow execution, which took place today at midnight. The deal involved 400 million XRP, which is presently worth $275 million. While the transaction appeared to be a typical escrow, DAI's rat is now caught in a mousetrap. Will Jeremy A's broken dock and hacked Twitter accounts ever be repaired? Will the party grow into a legitimate party? Will the revolution be broadcast on television? As an aside, David, is the secret sauce a mild or hot sauce? Despite various interpretations, it does allude to events within the XRP community. The document draws attention to the recently compromised Twitter account of attorney Jeremy Hogan. On July 24, hackers hijacked Hogan's Twitter account to promote a phony XRP giveaway, as revealed last week. The document requests that Jeremy Hogan's hijacked Twitter account be recovered. This inquiry arrives a few days late, as Hogan regained access to his account on July 29. The message on the document also prompts a variety of community reactions, given that it could have come from a Ripple employee. Notably, the writing style is comparable to that of posts produced by members of the XRP community known as Riddlers. A closer examination of the address that initiated the escrow transaction reveals that the person behind the address has been involved in messages like this since. On April 1, 2019, a similar message was seen in an escrow transaction involving 1 billion XRP. The XRP community is still in shock. The XRP community is too taken aback to figure out who is behind the messages. Who is the source of the messages? However, some supporters have previously mentioned David Schwartz. Schwartz, known for his sense of humor and ability to connect socially with the community, finds himself in the heart of the event. However, the most likely reason is that the memo did not originate within Ripple. It is vital to highlight that anyone, regardless of age, can initiate an escrow finish or escrow cancel transaction, regardless of whether they work for Ripple or not, if the prerequisites are met. Given this, it is plausible to assume that the memo was written by an XRP community member seeking the community's attention. However, without more information on the subject, this remains speculative. The key question of the day is whether the presence of an extra judge will give Ripple the victory. Will Ripple win because of the presence of an extra judge? Please remember to subscribe to our channel and press the notification bell to be among the first to learn about the latest XRP developments. Douglas Samuel Zolkind, a former SDNY attorney, has filed a notice of appearance on behalf of Ripple Labs in the company's legal battle with the SEC. Yesterday, veteran lawyer James K. Fillon tweeted about the development. The motion was filed in the Southern District of New York yesterday. In a motion filed Monday in the Southern District of New York, Zolkind expressed an interest in working with Debevoise and Plimpton LLP, one of the law firms supporting Ripple Labs in the legal struggle. Notably, Zolkind is a litigation partner at the law firm Debevoise and Plimpton. It's worth noting that Zolkind specializes in internal and federal investigations, as well as white-collar defenses. He attended the University of Pennsylvania and Cornell Law School. The lawyer specializes in criminal and regulatory enforcement defense for corporations and individuals. Zolkind worked as an assistant U.S. attorney in SDNY before joining Debevoise and Plimpton as a litigation partner. Notably, he oversaw numerous investigations and prosecutions in cases involving securities fraud, political corruption, overseas bribery, and cybercrime. Based on Zolkin's impressive resume, many of the XRP community have expressed excitement over his plan to join Ripple's legal team. However, his application to join Ripple's legal staff caused consternation in the XRP community. To clarify, crypto law founder attorney John Deaton stated that Zolkind would take the place of Lisa Zornberg, one of the lawyers who departed Ripple's legal team. According to sources, Zornberg was appointed chief counsel by New York Mayor Eric Adams. As a result, the departure left a gap in Ripple's legal staff, which Zolkind is working to replace. The SEC's move to appear on Ripple's behalf comes as the SEC indicates preparations to appeal Judge Analyst Torres' summary judgment. The SEC has indicated its dissatisfaction with the judge's decision involving Ripple's sales to individual investors. Judge Torres determined that Ripple's programmatic XRP sales on exchanges are non-security offers in his opinion. Several legal experts believe the SEC will appeal her ruling on Ripple sales to individual investors. There is also the possibility that the parties will reach an agreement to resolve the litigation. As previously reported, Judge Sarah Netburn directed the parties to choose 3 dates for a potential settlement meeting. Interestingly, regardless of the SEC's decision, Zolkin's legal skills will be valuable to Ripple in the litigation. Conclusions for XRP. So, gentlemen, we've reached the end of this video. If you loved it, please make sure to like the video, subscribe, and click the notification bell. This is quite beneficial. The YouTube algorithm and I. You can also help others become more aware, just as you have. Enlightened by sharing this video with as many people as possible. Let's spread the word, guys. If you are a true cryptocurrency enthusiast, don't miss any of our content. See you tomorrow to discuss the newest news that affects us all as a community.